This is the office of Mark Ritchie. This is where I was offered the email addresses of all those registered voters in the 4th Congressional District who had voluntarily provided it on their application form. This is where Mark Ritchie in 2007 took home 12,000 email addresses of civically active voters in political organizations and gave them to his campaign and raised funds. This is where a legislative auditor report investigating him held that these email addresses must be available to all persons. But this is where Ritchie keeps those addresses and only gives them to his friends, because he never gave them to me. Ritchie keeps different pools of email addresses, one for himself and a few select people, and one which he uses based on his discretion. I have provided this information to the federal courts in case 12 CV 2880, District of Minnesota. What the Minnesota Attorney General really raises for this court is the key issue. 1. Did OSS, Office of Secretary of State, have the obligation which they refused to provide the email addresses under applicable Minnesota statutes, the Minnesota Government Data Practices Act, Chapter 13, and the Election Statute, Chapter 209, and the United States Constitution. The subsidiary issues are: 1. Is there a difference in the eyes of the law between addresses from the Roundtable Civic Education contact information collected by the Secretary of State's office, which must be made available to any person for any purpose, and addresses for civic information contact information collected by OSS on voter application forms? 2. Did defendants materially mislead the court by saying they never gave these addresses of registered voters in or on the SVRS list to the candidates, parties, or registered voters? 3. If SVRS, that statewide voter registration system, SVRS data is something different under the law than civic education information, should it be put in a different legal classification and treated differently by the courts during the heat of an election, when Ritchie's can be used per the office of the legislative auditor, when in fact it is the same type of information, and in fact the very same information in many cases overlap between SVRS registered voters and civically active participants in roundtables from Congressional District 4. These key issues are discussed infra in the argument section. Since the court declined to dismiss based on the assertion of 11th Amendment sovereign immunity in this case, plaintiff will not address the arguments raised in the response based on the 11th Amendment. Defendants respond to my allegations of false and fraudulent submissions, as shown by new evidence, by seeking unsuccessfully to deny that any emails in the public list have ever been disclosed to any candidate or campaign, including Ritchie's own campaign for Secretary of State in 2007, for which he was sanctioned by the legislative auditor, and in fact countless DFL candidates who must be provided with these same civically active addresses benefit from his practices. But in doing so, he selectively accepts the findings of the Office of Legislative Auditor, and he clings to a single inapposite Minnesota Court of Appeals case, McGraw versus Minnesota Secretary of State, which he claims shows that he was bound by law not to release any address in the SVRS. Defendants argue that IPAD, that's the Administrative Division for Information Policy, or Administrative Department, doesn't make decisions about what Ritchie does with email addresses of voters and donors as the Chief Elections Officer. What he fails to realize, however, is that as the responsible authority and designee under that Minnesota Government Data Practices Act, he is bound by the law to establish policies and practices compliant with the MGDPA, the First Amendment, and the Equal Protection Clause, EPC, of the 14th Amendment, and Minnesota Statutes 209, especially 209.071, which authorizes collection of the addresses from registered voters, and 209.091, which in truth has nothing whatsoever to do with email addresses, but it is inappropriately used by defendants to manipulate the use of email addresses in their campaigns. Neither Minnesota nor its district court may lawfully disregard the commands of these laws ranked in this order: United States Constitution concerning, for example, Buckley, the Minnesota Government Data Practices Act concerning the OLA report and the iPad case, and election laws including McGraw and the iPad case. Facts. Defendants concede Ritchie in 2007 held, quote, roundtable discussions with various individuals and organizations at which those entities discussed their current activities and plans pertaining to expanding civic education in Minnesota. This is a pool of civic education voter contacts, which was 12,000 in 2007 and has presumably grown since, and which is available to all DFL candidates but was not available to me. The Attorney General Office then concedes point blank that, quote, the Secretary subsequently provided his campaign with email addresses from this compilation of civic education contact information, identical that too. Further, they admit, on October 29, 2007, 2 individuals who had received fundraising email messages from the Secretary's campaign as a result of the above facts filed a complaint with the Minnesota Office of the Legislative Auditor. On October 29, 2012, defendants informed plaintiff they would not allow me to have any of the email addresses. The court may take judicial notice that the Star Tribune reported November 21, 2007, that 12,000 names were on this list, which he described as active in civic life in the state. Ritchie said, they quote, he had personally provided a copy of the directory to his campaign and requested that those on the list get a copy of his campaign's civic engagement newsletter. It has been distributed to about 12,000 individuals and groups whom he described as active in civic life in the state. There has been no denial by defendants that many of the names overlap, so that many of those who voluntarily submitted their email address, being active in civic life in the state, on their voter registration form would have been in or on the civic education list and the SVRS statewide voter registration list. The word "from" lists whether the SVRS or civic education list is irrelevant to the legal requirements for making those available to registered voters and candidates for office for political or election use in Congressional District 4. There is no evidence that plaintiff asked for voter contacts from the SVRS. Plaintiff asked for email addresses in Congressional District 4, period. When those were denied, it was defendants who produced their reasoning based on the idea that the addresses were not regulated by the MGDPA at all, but only by the public information provision of 209.021. The OSS worker who offered the email addresses to me told me she had been doing it all wrong all these years by sending candidates over to get the email addresses. Defendants concede OLA explained that it was not improper for the Secretary to use roundtable contact information in this manner because the contact information was public data under state law. Therefore, quote, the civic education contact information collected by the Secretary of State's office must be made available to any person for any purpose, including the Secretary's campaign for campaign's purposes. However, defendants seem to assert or suggest that this directive too was not binding on the Secretary, even though it says the contract information must be made available. Notably, defendants fail to assert anywhere that they ever made these email addresses available to me, even though I asked for them. Even if it is argued that I asked for the email addresses from the registered voters in CD4 Minnesota, there is nothing in the Legislative Auditor report that says I have to specifically ask for the addresses to be given to me out of the civic education pool as opposed to the SVRS pool. According to the legislative auditor, this information about the roundtable addresses should be put on the election registration form because that is clearly included in the OSS obligation to make the contact information, quote, available to any person for any purpose, unquote. And my lawsuit argues that this should be expanded to clearly enunciate a pool that includes SVRS addresses. While the legislative auditor report I found is 5 years old, the information therein is material. But it is also new evidence which will affect a change in the result of dismissing the case on the basis of the positions taken supported by Poser's false affidavit. What is new is the additional evidence showing the falsity of the Poser affidavit and the baselessness of the state's legal arguments in light of the legislative auditor report brought by the state contending after the fact that there was some legitimate reason for withholding those email addresses from me, while at the same time falsely claiming that no candidate or party, including Ritchie and the DFL party candidates, had ever received email addresses in the SVRS. While Ritchie previously held he was bound by law not to release email addresses, or alternatively, belying this first contention, had explicit discretion to decide whether or not to release those SVRS addresses. And the court has so far overlooked this. It is also newly revealed that the defendants had the right to withhold this information, they say, because internally to OSS they had reasoned there was some material distinction between the sources of the email. They never disclosed these positions or the investigation of Ritchie's own use of OSS voter contact information in 2007. However, in earlier submissions, they have also sought to cover up the fact that other addresses, email addresses, in but not of or from the SVRS have been used for fundraising by Ritchie. His obvious conflict of interest in making this distinction makes it imperative that this court, not Mark Ritchie or Bert Black, review the applicable state laws and apply them within the context of the U.S. Constitution's narrow restrictions on blocking full debate in elections, have or have not been followed in this case, and is applicable to future instances which will undoubtedly come up in the future, requiring this court to address and decide the issue. The court should defer to OLA's finding that civic education contact information collected by the Secretary of State's office must be made available to any person for any purpose, rather than any argument raised so far by OSS, and should apply the same clear expression of legislative intent and therefore procedure required under the United States Constitution, Article 1, Section 2, to the SVRS addresses. Defendants present no argument why this finding by OLA should not apply to these emails as well. The finding of the OLA, that's the legislative auditor, that Ritchie must make available to any person for any purpose civic information, voter contact information, has not been changed by the legislature or challenged by OSS. Indeed, defendants stress that his actions of taking 12,000 addresses from the OSS office and using them for fundraising and making them available to all DFL members, but not to me, is totally proper and required by law. And though Hartshorn writes, "This is nonsense," defendants utterly fail to show any real distinction between email addresses collected from the two sources. The OLA ruling, which is binding on OSS by clarifying legislative intent, made no distinction between any of the email addresses based on source at all. And in fact, it violates the equal protection for them to distinguish by source, since the parties, Ritchie in 2007 and Carlson in 2012, are similarly situated. There is an OLA mandate to make this part of the SVRS data. That is to say, emails collected from voter registration forms public. This is so because the reference to the OLA report is to civic education contact lists. In voter registration and supplying email addresses available for political and election use is the highest form of civic education, period, and essential to the voting process itself. And a fraudulent attempt to block contact by withholding voter contact information in this situation is grounds for voiding an election. because it pollutes the purity, fairness, and freeness of the election process as a corrupt practice barred by state election laws, as an unfair campaign practice, and also violates the First and 14th Amendments. And yet defendants present the conclusory assertion: the report involved a public list, the OLA report involved a public list of email addresses, not SVRS data. And again, but as this court held, SVRS email data is different. But this is again deliberately misleading and unsupported. Nowhere in the record has this court ever discussed Mark Ritchie's 2007 use of voter contact information, and he surely has not mentioned it, much less has this court made any determination of comparison between the two sources of addresses because of their source. So what defendants do is twisted logic. It is true that based on a solemn assurance from the OSS that no candidate or party ever received email addresses that were in the SVRS system, this court, and I contend erroneously and in abuse of discretion, ruled that this case must be dismissed. And yet this says nothing about whether the very same email addresses of the same registered voters in CD4, or at the very least, the same type of information for the purpose of civic education voter contact by candidates and parties, collected from the roundtables, is public information. In fact, many of the arguments presented in the memorandum calling for dismissal could properly be brought against the OLA ruling defendants cling to. For example, that it would be spam email unwanted by voters, or that it would compete with the multi-million-dollar business of selling email addresses. But it turns out OLA says the civic education email addresses must be made available to all candidates and parties, and were not by defendants. Now they turn around and maintain that SVRS addresses are different than the addresses from permissible sources, but that difference is limited to the presumption that they wrongfully advance that it is because SVRS addresses are non-public or confidential and roundtable addresses are public. This is circular logic and tautological. And to break this circular logic, defendants must argue that there exists a classification establishing that just the SVRS addresses are definitely private, non-confidential. And that classification is not there. First, the only mention of email addresses in the election law is 209.071, which says the space will be put on the application form to be optionally provided by the voter. It's not in 209.091, which is a big part of the explanation why it is not in the public list, nor is it in the master list. The only possible reference then in 209.091 is that it may be provided, and as we have seen, that apparent discretion is overridden by both the OLA report, saying it must be made available to all, and the First Amendment and the 14th Amendment. For in addition to the fact that candidates like Ritchie and his party are unethically trying to provide campaign material to voters and organizations, including fundraising, being involved in civic education using roundtable addresses, there is this: those provided with the addresses from the roundtable pool and those provided with the addresses from the voter application forms are themselves similarly situated. In a federal election situation with all the First Amendment and constitutional rights, such as the states being responsible to decide the manner in which House members shall be selected under Article 1, Section 2 of the U.S. Constitution, the matter of how the voters and candidates and parties are situated is far more critical than the different sources from which the email addresses themselves might have been collected. This is even more certain because it is beyond dispute that many of those on the SVRS from the Congressional District 4 list are also going to be on the 12,000 or more individuals and organizations who are civically active. They are not going to be civically active and not registered to vote, are they? Civically active registered voters, when they officially provide their email addresses to the secretary in a roundtable, will be equally likely as civically inactive registered voters to provide their email addresses. Indeed, they will be more likely because of their heightened interest. Though I have already provided argument that the First Amendment requires free and unfettered access to the voters to present candidates' positions and views, and will not repeat that here. Thus the argument that, quote, the fact that the Secretary in 2007 treated a collection of indisputably public data differently than he treated the non-public data at issue in this case is entirely irrelevant to plaintiff's claims is plainly wrong. For whatever may be the merits of my argument, and I feel it is weighty and persuasive, the matter of the comparison of the addresses for voter contact from two purportedly separate and discrete sources is surely relevant, and the determination of whether they should be treated similarly or differently is key.